We are going to get started. This is our third and final summer webinar series from the JCMH. My name is Rose McBride. I'm the communications manager here at the Texas Judicial Commission on Mental Health. And today, thank you so much for joining our webinar, Forensic Commitments to State-Supported Living Centers for People with Intellectual and Developmental Disabilities. Today's session will provide an overview of how Texas law addresses individuals with IDD who are found incompetent to stand trial. Our panelists are going to walk us through the legal pathways under Article 46B of the Code of Criminal Procedures and related statutes, highlighting how these commitments differ from those involving mental illness, what happens when restoration efforts are unsuccessful, and what steps courts and providers can take when confinement in an SSLC is no longer appropriate. We'll also hear about the services and supports offered within SSLCs, including forensic assessments, competency restoration programs, and transition planning to help individuals reintegrate into their communities. We are honored to be joined by two highly respected experts. Dr. Dawna Campbell is the Director of SSLC Forensic Psychological Services at the Office of Forensic Services and Coordination at HHSC, where she oversees forensic operations and competency restoration programs across Texas SSLCs. And Beth Mitchell is the litigation coordinator at Disability Rights Texas. She has extensive experience advancing the rights of individuals with mental illness and IDD through litigation, advocacy, and systemic reform. So together, they'll provide clinical, legal, and practical perspectives on this complex and critically important area of the law. So welcome, Dr. Campbell and Beth. Thank you so much for joining us. And Dr. Campbell will kick it off.
Thank you, Rose. And thank you, everyone who's joining us today during your lunch hour. Okay. So what I'll be doing is providing an overview of state-supported living centers. I will talk a little bit about the treatment that's provided to individuals who are committed to state-supported living centers. I want to give a brief overview of forensic services that are offered at state-supported living centers and talk about the competency restoration program. And then if time permits, I have an example case to kind of illustrate all these points. So we have 13 state-supported living centers across Texas that are operated by Texas Health and Human Services. And these facilities provide campus-based direct services and supports to people with intellectual and developmental disabilities. They also serve people who have who are medically fragile, have behavioral challenges, and have mental health issues. So, excuse me, I just have a map here that shows how these facilities are located across Texas. We do have two facilities that are designated specifically for forensic, and that is Mejia for males and San Angelo for females. So as I mentioned earlier, these places offer residential services that are intended to serve individuals who have severe or profound intellectual disability, or ID as we refer to it, or individuals who have ID that may not be in that profound or severe range, but may be more in the moderate or mild range, who have significant medical issues that require a lot of care, or individuals who have significant behavioral needs that require intensive supervision. And then we also have the individuals who are committed by the courts due to high behavioral needs, or maybe they have charges. So this is these are the treatments, some of the treatments that are offered in the state-supported living centers. We have what we refer to as positive behavior support, and this is provided by our behavioral health specialist. And the behavioral health specialist will work with the individuals to identify target behaviors, which are usually behaviors that prevent someone from being successful in a less restrictive setting. For example, it may be aggression toward others, or inappropriate sexual behavior, or self-injurious behavior. Those are just a few examples. There are many others. And then they work with the individual to identify replacement behaviors. So for example, to replace aggression toward others, the individual may learn to ask for a break. And the goal is to decrease the target behaviors while increasing the replacement behaviors. And these behaviors are tracked and graphed so that the treatment team can keep up with how the behaviors are decreasing and increasing. We also provide psychiatric care. We have psychiatric providers who prescribe psychotropic medications. Now, we do not do PRN psychotropic medications like the state hospitals do, and that would be, as needed. However, we are able to provide emergency medication in crisis situations once all other interventions have been tried and failed. We also have medical treatment. We have PCPs and nursing staff are available 24/7 on the facilities. We also have HAB services that includes occupational and physical therapy as well as speech therapy. And then we have what we call skills acquisition. We have staff who work with the individuals to identify skills that they want or need to learn, which may be something like money management, cooking skills, a lot of independent living skills. And then plans are developed to teach, for the staff to teach individuals these skills. State supported living centers have vocational training, and that includes jobs both on and off campus for those who qualify. When we have individuals admitted to the facilities who are still in school, then we provide education through the local school districts. We also offer counseling. We have licensed professional counselors, or LPCs, and then the behavioral health staff as well, who provide group and individual counseling. And then all individuals, once they are admitted to the state supported living center, the staff begin to work with them on community reintegration. So this is done by their interdisciplinary treatment team, or the IDT, working with the individuals to develop goals that will help them reintegrate back into a less restrictive environment. And then they identify barriers to the goals and help the individuals overcome those barriers. Some of the other things that we do to foster community reintegration are community outings, which are supervised by staff, where the individuals will go to local community gatherings such as churches or sports events, going out to eat, going shopping. And then if the family is available and able to do this and the individual's behavior is stabilized enough, then they may have some home visits. We facilitate family involvement. Oftentimes individuals come to the state supported living center and they may have lost contact with family, so we help to reestablish that contact with family. And then we facilitate visits and phone calls. And then once the individual is ready to transition into the community, we try to provide step-down housing for them, such as group homes, where the group homes usually have a lot of the same services that the state supported living center has, including 24/7 staff supervision. So even though they're in the community and they are a less restrictive environment, the individual's not making that big of a change when they step down into the group homes, and it helps them to acclimate into the community. Sometimes we may transfer individuals to other state supported living centers that aren't designated as forensic once their behaviors have stabilized. And these facilities may be closer to their families, where the families can visit more often. And then once the individual has transitioned into the community, we work with the local Intellectual Developmental Disability Authority, or the LIDA, to establish continuity of care. So whatever services they were receiving at the facility, we help to set up those services in the community. So whether it's psychiatric care, mental health care, have HAB services like occupational therapy, we try to get those services established for them in the community. And then once the individual is placed in the community, our admissions and placement department follow up with them for at least a year. And during that year, if the individual experiences issues, we work with the LITA to help them overcome those issues. If they have problems that they're not able to overcome during that year, then they may return to the State Supported Living Center. And they don't have to have a hearing to do that. So they're still considered residents of the State Supported Living Center during that year. So these are the forensic commitments that we get at the State Supported Living Centers. We have what we refer to as extended commitments of adults who are found to be incompetent to stand trial and also have ID when they've also been found unlikely to restore to competency. And this is through the Code of Criminal Procedure, Chapter 46B 103. Now, these are not time limited, so it's up to the IDT or the treatment team to determine when the individual is ready to transition to a less restrictive environment. We also get some that are committed to us through Chapter 46C, and these are individuals who've been found not guilty by reason of insanity and also have diagnosis of ID. And these are treated pretty much the same as the extended commitments in that they are not time limited and it is determined by the IDT when they are ready to transition. We have minors who are committed through the Family Code, Chapter 55, who have pending charges when they've been found unfit to proceed. And they also meet civil commitment criteria. And these are also, we also refer to these as extended commitments because they are also not time limited. And then we have the individuals who are committed to us for competency restoration or fitness to proceed restoration services through the Code of Criminal Procedure in Chapter 55. And I believe Beth is going to speak more on those, so I won't say much more about those right now. So the forensic services that we offer at the State Supported Living Centers are the competency restoration training, which I'll speak more about in the next few slides. And we have what we refer to as high-risk determinations or HRDs. And this is a process where once an individual has come to us on an extended commitment, we have a meeting where the IDT discusses their observations of the individual, their history that we've read about them, and everyone on the IDT provides information about how they've been doing so far at the facility. And then we also do a violence risk assessment by psychology. And once all of this has been discussed, they have a meeting which involves the director of the facility and a representative from state office, and they determine whether or not they believe the person is at high risk of inflicting substantial physical harm to others. If the individual is determined to be high risk, then they are not eligible to transition to a less restrictive setting, including a state supported living center that isn't designated as forensic, until the team meets again and determines that they are not high risk. And this is done, reevaluated at least on an annual basis. We also do forensic assessments that include the violence risk assessments and the competency and fitness to proceed evaluations. We have individual and group counseling that is designed to address offense-specific behaviors, such as sexual behavioral treatment. And just like all the other individuals that are admitted to the State Supported Living Centers, the treatment team begins to work with them on community reintegration as soon as they're admitted to us. And we work closely with the court and the LITA to ensure that they have a smooth transition. So our competency restoration is based on the definitions of that are provided to us by the Code of Criminal Procedure and the Family Code, which you can see here. We also provide them the holistic treatment, which is provided to all the state supported living residents, and those include the treatments that I already discussed, including legal education. So the legal education is based on the Slater method, which was developed specifically for individuals who have intellectual disabilities by the Eleanor Slater Hospital in Cranston, Rhode Island. We also use pre and post tests to determine what level an individual is in the beginning of the treatment, possibly midway through treatment, and once the modules have been completed. We also use supplemental materials, which include games and videos, sometimes music and other like flashcards and things like that. And then we use a mock trial video in which we show the individual how things work in the courtroom, what the different court personnel do, and where they're situated in the courtroom. And then we also teach relaxation techniques to help them learn to manage stress. So the Slater method has a workbook that includes 5 modules, and each module has 2 phases. The first phase is the knowledge-based training, and this is where factual information is taught. The individuals learn definitions, the roles of the different courtroom personnel, and the different proceedings in the courtrooms. And then phase 2 is the understanding-based training, and this is where the individuals apply that knowledge to their own cases. It also has a guide for trainers and a glossary of legal terms. So these are the training modules, and as you can see, it does cover the information that individuals need to learn in order to become competent, including learning about their charges and what their charges mean, the different pleas and the potential consequences. As I mentioned earlier, what the courtroom personnel, their different roles, and the review of courtroom proceedings, including a trial and plea bargaining, which is a very complex concept, and it takes a lot of time to help individuals understand that. It also goes over working with their attorney and assisting in their defense, and then we work with them on tolerating the stress of proceedings. You can go ahead and go to the next slide. It was supposed to, yeah, there we go. So these are some of the outcomes once the individual has completed their competency restoration and they've received their evaluation, their psychological evaluation. If they're found competent or fit to stand trial, once the report is sent to the court, they will likely be discharged to face their charges in the community, in the county. If they're found incompetent or unfit and likely to restore, then we may request an extension or a recommitment to continue treatment. For example, we had an individual who had some medical issues and had to have surgery and was out for an extended period of time at the hospital and then at a rehab center. So we had to request an extension for that individual. Also, they may be found incompetent or unfit to stand trial and not likely to restore. And once the report is sent to the court, oftentimes they are recommitted for extended care. Okay, I think I'm kind of running short on time, so I will save this for the end and go ahead and pass it on to Beth so that she's able to complete her part.
Great, yeah, we can come back to that if we have time. So Beth, I'll get your PowerPoint up.
Okay. Thanks, Dr. Campbell. That was great. I think as she's getting the PowerPoint up, there are a couple of questions that maybe you could answer as she's working on that. One was, is HHSC tracking how many of the forensic admissions to the SSLCs are people who were at an HGS group home, on the waiver list, or asked for a commitment to an SSLC prior to arrest?
That is a question that I can't answer at this point. I'll have to do some research on that and
Okay.
find out.
And then the other questions, one was about what are the measures being used in violence risk assessments? And are they more specialized measures designed or researched for ID individuals?
Right now, what we're using for the violence risk assessment is the START and the HCR 20 version 3 for adults, and then we use the START and the Savory for juveniles.
And then the last question, I think related to HHSC is how effective is the Slater method? Are there any outcome evaluations? Is there any indication about percentage of people who are determined competent using that method?
That is something that we are also working on to gather that data. And we are going to look at the competency restoration training that we're doing and possibly do some revisions in the future.
Mine is going to be more heavily legal based and not as psychology and risk based. And it's really going to go through the pathways for commitment and how those pathways are a little bit different than they are for individuals found incompetent to stand trial who have a mental illness. So first slide is once a person is found incompetent to stand trial, and they are then determined either likely to be restored and not released on bail. So if they are likely to be restored and only likely to be restored, they can be committed either to a mental health facility, an SSLC, a JBCR, or an OCR. Doesn't matter, right? So even if they have purely just an intellectual disability and they're determined to be manifestly dangerous, the commissioner could determine that Vernon is the appropriate placement for the person and they could go there even though they don't have a mental illness. So this first commitment under 073 is not about what type of disability the individual has. It's just whether or not they're incompetent and what's the most appropriate placement for them to be restored. And so those are all of the different places that they can go to, and it's all based on the commissioner or their designee determining which is the most appropriate placement. The length of commitment for people who are on a misdemeanor is 60 days, and they can get a 60-day extension. They're only entitled to one extension. They can't keep getting 60-day extensions. There's only one 60-day extension, and that's the same thing for felonies. That first competency restoration commitment, the initial commitment, is 120 days, again with only a 60-day extension. Once that period is over, 15 days before that period expires, I think Rose is trying to get to a slide that has a full screen on it, maybe.
Are you seeing the full screen now?
No, it still has
Not
that
yet. Okay.
half screen thing, but
Okay, I'll work on it.
so the next slide is 15 days before that restoration period is over, be it 60, 120, or 180 days, whichever it is. The program, wherever that person is, JBCR, OCR, whatever, sends a letter to the court indicating whether or not the defendant has attained competency. And if they have attained competency, trial resumes, right? If they have not retained competency, will they retain competency in the foreseeable future or not? And that's the other question that's asked. At that point, if the person is, and let me go back to one other thing. The prior slide under 073, right? The purpose of that commitment, that original commitment, is for competency. If the person was found unlikely to be restored, they should not be committed under that provision because there's not a likelihood that they will be restored, so there is no need to provide restoration treatment. The treatment that Dr. Campbell was discussing in terms of all the various methods they use to get somebody competent for trial is not necessary if they've already determined the person is unlikely to ever be restored. So but under 079, once they determine that the person is unlikely to be restored or won't be restored in the foreseeable future, they can proceed under subchapter F, where their charges are not dismissed, or where their charges are not dismissed, or subchapter F, where their charges are dismissed. Most likely, charges are not going to be dismissed, and so the likelihood is the court will proceed under subchapter E. Subchapter E talks about civil commitment, and next slide, and which section of subchapter E is important, right? So if you are now committing the person because they have a mental illness, and you think that mental illness is causing them to be a danger to themselves or others, you go under 46B102. However, if the person has an intellectual disability, and even if they have a mental illness, but it's their intellectual disability that is causing them to be either dangerous to themselves or others, or unable to care for themselves, then you go under 46B.103. Okay, so that person could still have a mental illness, but that's not what's causing their dangerousness. So in those situations, you're going to go under 103. 103 basically says, like, similar to 102, right? You basically still go back to the civil commitment standards, right? Because now what we're committing the person for, the purpose of this person's commitment is because they need to be basically civilly committed. It's through the forensic process, but they need to be civilly committed. The purpose is it's not really any longer for competency restoration. Could still provide competency services, but that's really not the basis of their commitment anymore. Their current commitment now is because they meet civil commitment criteria, and that's why they're being committed at this point. And so under 103, it says to go to review this based on, next slide, on the procedures under subtitle D of the Health and Safety Code. These procedures are significantly different than the procedures for involuntary commitment, partly because they came out in 1993 and never got changed, whereas the Mental Health Code has repeatedly seen changes throughout the years. But the PIDA, the Persons with Intellectual Disability Act, has not seen those kinds of changes. So that statute is pretty stagnant, and what's there has remained there since, like I said, I think like 1993 or 1991 even, is where most of the laws come from. So you will see significant differences. One of the initial differences that's required, next slide, is that an application for SSL commitment is required, and this is under 46B103. You need this application. 46B says you don't need an application to determine the person has an intellectual disability, but it does not say you don't need an application for the commitment and the application for commitment requires an IDT report. Okay. So an IDT report is I'm going to say it's a lot like the CMEs, but it's not. It's very much different, but it stands in place of the CMEs. You do not get CMEs for a placement in an SSLC. You get an IDT report. That IDT report has to recommend placement. And if an IDT report has not been completed within the last 6 months, the court has to request an IDT report or a hearing cannot go forward. And if there is no IDT, and the IDT report, if the IDT report does not recommend placement at the SSLC, a person cannot be committed to the SSLC. So just like the CME, if the CME says the person doesn't meet commitment criteria, they can't be committed. Same thing with the IDT report. If the IDT report says they can't be committed to the SSLC or they don't meet the criteria for the SSLC, they can't be committed to the SSLC. IDT composition, because this also becomes a big issue in these cases, is that oftentimes people don't know how to really do it. Not that people don't know how to do an IDT. I think there are a lot of LIDAs out there, and although SSLCs are very apt at doing IDTs that are very comprehensive, LIDAs are not as familiar with doing IDTs in forensic cases. Certain LIDAs are, because they do them all the time because they get a lot of them. But there's a lot of other LIDAs that are not familiar with this at all. And so related to what is needed to commit somebody to an SSLC. And so in this case, the individual should be part of this, the LAR, if there is any, qualified professionals with special training and experience, and it can include others as well. But those have to be part of the IDT. So in this case of INRAE AW, the individual was not involved. It was just one caseworker writing a report herself. And the court said that was not a sufficient IDT and required and remanded the case for a appropriate IDT report to be completed. So you need to have the individual, the LAR, and these qualified professionals all sitting down together. And then the next slide talks about what it contains, right? So their medical and social history assessment, the services and preferences, and then ultimately, does the person need to be at the SSLC or not? Or is there a less restrictive environment that the individual can be habilitated at? And so those are the criteria. Once you have an IDT report that actually potentially does recommend commitment to an SSLC, the criteria for commitment to an SSLC is also different than it is for a state hospital. So the next slide, the criteria for commitment says that the person has to have an intellectual disability, and because of the intellectual disability, there is substantial risk of harm, which we know is kind of the same as state hospital, or cannot meet their basic needs. Again, kind of the same thing as a state hospital. Here, though, least restrictive alternatives are unavailable or unable to meet the individual's identified needs, and the SSLC can meet their needs. So the biggest change is that on top of the least restrictive and that the SSLC can meet their needs, is that all four of those findings have to be proven beyond a reasonable doubt. The state has the burden of proving that beyond a reasonable doubt. Under the mental health provisions, under 102 or Health and Safety Code 574, it's clear and convincing evidence. So this is a higher burden of proof that the state is required to prove. Part of that being that, as Dr. Campbell had suggested, this is a long-term commitment. There is no end date. So there is no actual court review necessarily, or at least any kind of periodic court review of this commitment. So that's part of the reason why there's that higher standard. The other reason for the higher standard is back when it was first, the Supreme Court first discussed the issue, there weren't as many, which is back in the 70s, the idea of habilitation was not as profound as it is now, right? The belief that people with intellectual disabilities can be habilitated and can be moved into lesser restrictive environments. So that's kind of the reasons behind the beyond a reasonable doubt standard. But again, all four findings must be found beyond a reasonable doubt. On the next slide, so when you're looking at kind of some of the definitions, right? Intellectual disability, even though you don't have to have an application for an intellectual disability, the person's still required to have an intellectual disability, which still means sub-average intellectual functioning and adaptive deficits from the developmental period. So before the age of 18, they have to show that they had sub-average intellectual functioning. So people who might develop, who have autism but don't develop signs of sub-average intellectual functioning until later in life would not be included, right? People who maybe got a traumatic brain injury later in life, they are not included in this definition and would not be appropriate for an SSLC placement. When it talks about residential care facility, because that's actually the definition, is commitment to a residential care facility. Residential care facility is defined only as an SSLC. And then least restrictive alternative is least confining, least intrusive setting appropriate to the individual's need. So I just thought those were some that were helpful. And if you see at the very beginning of at the title, I kind of put the sections of the code where you can find some of these definitions and laws that I'm referencing. So in terms of who can make a determination that a person has an intellectual disability, basically it's any licensed physician or psychologist who in the state can make that determination. Or some other professional that's been certified by the department can also do it. Generally, a person can appeal a finding that they were found to have an intellectual disability. It's an admin hearing. So if it is determined that they have a intellectual disability and they don't think they do, they can appeal that determination. And once a person has been, especially by a court of law, determined to have an intellectual disability, it becomes very difficult to remove that that the person has an intellectual disability. Okay, next slide, substantial risk. So Dr. Campbell kind of went through this, go through it a little bit more, but IQ is 4 plus standard deviations below the mean, which means it has to be below 70. And then they have an ICAP, which is their level of functioning has to be pretty much what Dr. Campbell was saying. They have to have a lot of nursing needs, right? Some significant nursing needs or self-care needs, or dangerous behaviors needing intensive staff support. That's what's required based on HHSC's rules related to who meets the criteria for their commitment. So the duration of a forensic commitment, as Dr. Campbell did say, there are no set term limits. It is long-term once the person gets past that initial just for competency restoration, but goes forward to a regular commitment to the SSLC. It is a long-term commitment. But many Supreme Court cases discuss that even though it's a long-term commitment, that doesn't mean a person never gets to leave, right? They say that just because an initial confinement was proper, the person did meet criteria, constitutional criteria, once that criteria ends, the person must be released. And so when that criteria is no longer met, if there is a defense attorney who believes that person no longer meets that criteria, they should raise that. Oftentimes it's the IDT themselves at the SSLC who raises that the person no longer meets commitment criteria. And once they raise that, so this is kind of what happens once it gets raised. Next slide. So once it gets raised, what should happen is once it's raised, the head of facility should notify the court 14 days before the defendant is about to be released that they no longer meet criteria. What the SSLC has done to help try to encourage the support of all involved in this individual's care is to send a first letter to the court. And I've redacted a copy of ones that we've seen previously. The first letter basically says that the person has been recommended for referral to usually to an HCS home, right? Like that's generally where a person at an SSLC is going to get referred to as an HCS home, that they have been referred to an HCS home, and that that they have a right to receive the services in the least restrictive environment. It also talks about how once a person is discharged from the SSLC, that they will be monitored by both the LITA for a period of time as well as the SSLC for a period of time. The SSLC monitors them at a period of 7, 45, and 90-day intervals, and then quarterly thereafter for a year. Whereas the LITA should be monitoring them on a quarterly basis for the duration that they remain with the LITA. But this first letter really is to tell the court that the person's ready to go, they're about to be discharged, and it's a way that the SSLC can work with the court and work with the prosecutor and work with defense counsel to make sure that everything is in place before the actual final hearing. And to make sure if there are any doubts that everybody works together to figure out what those doubts are so that they can remove the doubts and move forward with the appropriate release from the hospital. And so after this letter, there's no indication from the SSLC how long they'll wait for everything to get going. I mean, part of this too is that what the SSLC does is once they've determined a person is appropriate, they start to try to find HCS homes that a person can go to, right? And so they don't just throw any HCS home out there. They let the client go and choose which ones they think, along with the client, is going to be the best fit for the client. And so the client goes and looks at those homes and chooses which home, or along with the LAR if they're there too, might be the best fit. And so oftentimes the SSLCs don't want to get clients' hopes up if in fact the court is just immediately going to deny that request. So some of this letter is to try to eliminate moving into that direction until they have a little bit more assurances that the court might actually listen to at the hearing about whether or not the client is ready for discharge or not. So a couple things with this letter. I think this is a great way personally, I think this is a great way for the courts and the SSLC and everybody else to work together. My only fear is that I would not want this to drag on forever. If the person is ready to go, they should be ready to go, and they should get their due process hearing and a right to their hearing and have the court determine whether or not they meet criteria, because then they have the ability to appeal that decision if in fact the court decides they're not ready to go. And so I think that there needs to be some timeline, and I don't know that there's not, but that there needs to be some timeline after which the SSLC says, well, we've worked with you, the court, but we can't get you on board, but we're going to go ahead and send our second letter. And so I'll let Rose pull up the second letter. So the second letter basically is a lot like the first letter. It says whether or not, it attaches a report about the person being incompetent to stand trial. And then it actually lists out who the HCS provider is. So that everybody knows where the person will be going. So it lists out who the HCS provider is, and that the HCS provider is going to be able to provide for the care and treatment, and that the person should be discharged within 14 days of this letter, but the letter goes on to say that they won't discharge without notice of the court. But in reality, the way the law reads is that either at this point, the court is required to have a hearing within that 14 days. So once this letter is sent, the court is required to have a hearing. When that court has a hearing on release from the HHSC, is the next slide, they're required to follow, next slide after that. So they're required to go back to subtitle D, right, of the Health and Safety Code. You're required to go back through slides. You go to the slide 15. There, yeah. So once that letter is sent, that second letter is sent saying we're going to release in 14 days, the court's required to have that hearing within 14 days to determine whether or not the person can be released. In order to not release the person, they have to find that the person still meets commitment criteria, which means they have to go back to the requirements of subtitle D of the Health and Safety Code, which was slide 714, which talks about they have to have the IDT report that says the person does need to stay at the SSLC, and that it's not the least restrictive environment. So they again have to meet all of those criteria beyond a reasonable doubt. If they don't meet the criteria, there's several cases out of the Fifth Circuit, Supreme Court has also, that if you don't meet commitment criteria, it's the Fifth Circuit has dubbed it as the commit or release rule, right? Requires the release of the individuals who do not meet civil commitment criteria. So, and I know everybody's like, oh no, what do we do? Just releasing them. So here's the other big problem with which I think the Judicial Commission had tried to fix this last session, but it didn't get through, which is the next slide. This is again a big difference between a person with a mental illness and a person with intellectual disability. Person with a mental illness, The law under 574 explicitly allows for an outpatient commitment, not a competency outpatient commitment, but just a regular outpatient commitment. That is not true under the IDD provisions. There is nothing that allows for an outpatient commitment or conditions, right? You can't release them on a personal bond under 032 because it says they have to be competent to stand trial in order to be released under 07 to be released on bond under 032. So that doesn't apply, right? And then even bail decisions under 17028 talk about if they can't execute an affidavit, which generally if this person is incompetent with IDD, potentially not restorable, they're not going to be able to effectuate that. It just tells you to go back to pre-incompetency determinations, which don't apply. And then the other problem is that, and I'll show you, is if you compare the language of the statutes on the next slide, right? So under subtitle C, right, under the mental health code, you have an explicit provision 574.0345 and .0355 that talk about an order for temporary or extended outpatient mental health services. Explains what those are. You know, you have to have a severe and persistent mental illness, and a result of that mental illness, again, you meet criteria. You get conditions, right? They can order that you follow a general treatment program. The difference, but even under the mental health code, a failure to comply with that program is not grounds for punishment or contempt. So you can't bring somebody back to jail just because under the mental health code, they would not, they don't follow the general treatment program. What you can do is do another hearing to see if they meet criteria to be committed back to the state hospital. The problem is that under subtitle D, which is this section of what is required for individuals with intellectual disability, there's none of that. There's no suggestion of a commitment to a residential commitment to the community or anything else. There's no conditions that are mentioned in that provision. So there's nothing that allows for any of that. Again, even if you look at, you know, Code of Criminal Procedure 46C, it allows for outpatient community treatment. It allows for conditions. And then it talks about modification. So it provides all of that under if a person was found, not guilty by reason of insanity, which of course there are very few people who have just an intellectual disability that reach that point. So there is a gap in the law related to individuals under intellectual disability. And like I said, the Judicial Commission had tried to develop a bill, or did work on with the legislatures to draft a bill that would have provided an outpatient provision for people with IDD, and it just got tied up with everything else. But what I suggest is that if you are working with a person who has an intellectual disability who does not meet commitment criteria for an SSLC anymore, that you can use, I've come up with a sample transfer order, which is on the next slide. And this kind of follows along with what the Judicial Commission originally was working on to develop for an outpatient commitment provision. And as
I'm
Rose-
working on it.
Yeah, so as she works on it, so basically it says, it kind of follows the mental health outpatient commitment provisions, right? It kind of says, okay, the IDT has come up with a report with a treatment program, and the person should follow that treatment program. But if they don't follow that treatment program, you can't send them back to jail. You can't punish them. What you have to do is you have to see if they continue to meet, if they now meet commitment criteria and go back through a commitment hearing, right? And so it kind of ends with that, but the beginning talks about, and there's some provisions because there's a lot of people who end up, not a lot, but some of the people who end up at the SSLC. So this one is tied more to somebody who had an inappropriate sexual contact. And so this talks about, they shouldn't be around the victim. They shouldn't be around kids younger than 17 years of age. So some general provisions, but again, nothing that would require that they be immediately forced back into jail or punished in any way. So as you can see, it talks about they were found incompetent. They had a hearing. Under the hearing under subtitle D, they don't meet commitment criteria anymore, but they're gonna be on an outpatient. That outpatient, and if you scroll down some more, so here it talks about, right here, they're ordered to not have contact with the alleged victim. Here's, like I said, the 17-year-olds, that the group home staff shall contact the SSLC if they've had any sexual contact. But then it's other ordered that that people they'll talk about what's going on and stuff, but that ultimately at the very end, that that I think scroll down further. Yeah, that if the defendant fails to comply with the CLDP or any amendments incorporated into this order, it's not grounds for punishment or rearrest, but the court may set a hearing to determine if the defendant meets criteria identified under subtitle D again, right? And then there's an expiration on this. It's not just an ongoing forever order, there's an expiration. And so this is something that I think people could use if they're dealing with individuals with intellectual disabilities, that does not require a person, what I've seen in several cases is that courts end up rearresting the person and bringing them back into jail. And then the person sits in jail, which is the worst place for a person with an intellectual disability, right? We know how often people die with intellectual disabilities in jail because they just don't know how to advocate for themselves. It is the worst place for them to go back to. They significantly decompensate, even more than people with intellectual disabilities. So sending them back to jail has got to be the worst thing for them, and the law does not allow for it. There's nothing in the law that allows for that, and we should really work hard to prevent that from happening, both for the client and, and to ensure their due process. Okay, that I've way run over my time, so I'm stopping.
Yeah, I was gonna say, you have, you're very popular, both of you have a lot of questions. If you want to start looking through the questions in the chat. Or is it in the Q&A? In the Q&A?
In the Q&A, and I just wanted to let everyone know that any questions that we don't get to, we will be sending out a follow-up email with answers to your questions, as well as the presentation slides and information about the CLE or CEU numbers. But we'll let Dr. Campbell and Beth look through some of these questions and see which ones they can answer right now.
I'm looking at the bottom one, just out of the Senate Bill 944, the 0511, which I'm assuming is the what that section was originally meant for, was for people who could actually be sent on outpatient from a maximum security facility, right? But if you actually read 944, even though it talks about both individuals, ultimately it refers back to the outpatient commitment standards under the mental health code. And so the person would still have to have a mental illness, and the mental illness cause the need for the commitment. So that section wouldn't apply in this situation anyway. Isn't IDT necessary to commit juveniles but beyond the Chapter 55 order? So, and that goes back to, I think, if we're talking forensic versus civil, right? If you go back to our original, I think there was a presentation a month ago, and there was a new provision that was added for civil commitments of children, that if there was a guardian, the guardian did not have to have an IDT in order to have the person committed. But as for a forensic, it's the state who is doing the application, and because the state is doing the application, an IDT would still be required. It's only when the guardian is doing the application, and the guardian can't do the application under a forensic commitment, under a Chapter 55 commitment. I don't think somebody asked if the IDT report is older than 6 months. Can the parties agree or stipulate to the use of that IDT report? That's statutorily required. So I don't know if they could actually, I think it would depend. I mean, if the defendant was willing to agree to it, I guess they could, because nobody would argue it would be jurisdictional. but it may be at least, somebody might challenge that the law requires it to be within 6 months. So I think there's part of that piece, but there could be where if like there had been continuances to a hearing that would make sense that you would agree to extend that 6-month deadline. Can we request an IDT report on a 46 client who has already been returned from the state hospital? So I'm assuming, and I'm not sure, but they've been returned from the state hospital and now everybody thinks they need to go to an SSLC because they originally were at the state hospital because they've had a dual diagnosis. So yes, the court can, if the court is trying to commit them under the 46B 103 provisions, then the court can request that an IDT report be done prior to that commitment. But if they're coming back from an SSLC, from a state hospital, just to re-go to a state hospital, there wouldn't be a need for an IDT report. You would do the CMEs. So HHC questions. Absolutely, IDD individuals have a right to accommodations during legal proceedings. And in terms of I know Disability Rights Texas does receive complaints regarding issues related to fair and equal access to justice, and I know Texas Civil Rights Projects does a lot of that, and I know ACLU does a lot of that, so I think all of those people do a lot of those things.
Could you just repeat the question? I'm not sure if I can see it.
Sorry. Do individuals with ID have a right to accommodations? It was by William at 12:26 p.m. during legal proceedings. And then I'm just kind of going up. Is it a right for a misdemeanor class B an initial 60-day commitment only and no extension? No. Everyone gets a 60-day extension. Misdemeanor or felony get a 60-day extension. So, but it's 60 days for either. And so, I think one of the things again is really that should, if a person was found incompetent and unlikely to be restored initially, right at the very beginning, there shouldn't be a 60-day or 90-day, right? Like commitment, because that commitment solely for competency restoration and that person's already been determined unlikely to be restored. So you should move directly into the other one. And then we could have the court do a commitment if they make a finding beyond a reasonable doubt. I'm not sure I understand that question. I thought we could have the court do a commitment if they make a finding about beyond a reason.
I think that was in response to that you have to have the IDT.
Right, but the court can't even get to making a finding beyond a reasonable doubt if an IDT report is not submitted that says the person that says SSLC is appropriate, is the problem. So you have, just like a CME, right? You can't the court doesn't even get to say there's clear and convincing evidence if there's no CME submitted that says the person has a mental illness or that the person is a danger to themselves or others. It's the same thing with the IDT report. So a court doesn't even get to say, oh, I don't care what the SSLC says, what the IDT says. I'm saying that they meet criteria beyond a reasonable doubt, so I'm recommitting them. They can't do that without that IDT report.
We'll do one more answer and then we're at time. So if anyone has to jump off, like I said, these will be emailed to you afterwards, as well as it sounds like people would like some links to the previous 2 webinars. So I'll include those in the email as well. But let's do one more question.
Is there anything that can be done to keep individuals from sitting in jail while they are awaiting a bail at SSLC after the civil commitment has been ordered? I sure do wish there is. You know, DRTX has filed a lawsuit. The lawsuit did not cover the SSLCs at the time. It only covered state hospitals of persons with a mental illness found incompetent and waiting for a state hospital bed. A federal court has ruled that it is a violation to keep people in jail waiting for a state hospital bed who have been found incompetent to stand trial and are waiting commitment for competency restoration services. There's actually a bench trial set for that at the end of December to determine what length of time the court says is constitutionally allowable for a person to remain in jail before they are moved over. I would imagine that when and if that decision is made, that the SSLCs will see the writing on the wall and follow suit in terms of trying to move individuals with intellectual disabilities over to SSLCs more timely, which potentially may mean having to build more beds, which is what the state hospitals are doing. And I think that's where we all come into play, because I think building more and more places is not ultimately the answer, right? We don't want to be a state that just has a whole bunch of alligator Alcatrazes everywhere. There's nothing to indicate for mental health or IDD that keeping a person institutionalized helps them. It warehouses them, and warehousing them may be for some a primary purpose, but that is not for an individual. That's not their constitutional right. And so we need to look at ways that we ensure that people who are in the institutions necessarily do need to be there, because there are some that do. I'm not saying that we don't need institutions. We do. There are people who do meet those requirements and do need to be there, but we need to make sure that the people who aren't, and they move into the community. And part of that is ensuring that we have more housing for people, more supported housing, more, supervision housing for people in the community, so people can move over to the community when it's appropriate.
All right, well, thank you so much, Beth and Dr. Campbell. This was a great presentation and discussion, clearly a topic with a lot of interest. So I just wanted to thank both of you for your presentation today, and thank you to all of our attendees. Look forward to that follow-up email. And this video will also it's been recorded and it'll be on our YouTube channel if you want to go back and watch it again. But thank you. And thank you to those of you who have also attended all 3 of our webinars. We really appreciate it, and have a great rest of your day.